what they offer you is gray and promises dystopian control. They offer you safety and security purchased with the currency of your freedoms. But on this channel, we say absolutely not. The warmth and freedom of individual liberty will pass on from us to the next generation, and it starts right now. Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors, the place where we not only talk about what's going on in the gun world, but also our incredible country and how we're going to fix all of it together. The content that I'm going to talk to you about right now is something that I've never seen happen before in my entire career. A circuit court just reversed their opinions on suppressors being arms. Again, I haven't seen this before. X is ablaze with all of this and all the different instances of where it hasn't happened again. And then I'm going to show you what it means. Everything will be linked in the description box below, of course. Make sure you hit that like button, subscribe to the channel, turn the notification bell on, because the more you do it, the more you defeat that censorship algorithm and you stick it right to the gun controllers every time they try. All right, let's get into this, guys. Everything that I show you is always on my X profile at Braden LOA, so make sure you jump over there. And before we get into the content, make sure you guys check out the link in the description. USCCA has put out free training in light of all the riots, all the protests, the increase in temperature that's going on. Make sure you are trained with not only your physical firearm, make sure you are trained with your awareness of your legal ramifications in your state, but also just strategy and defense. Guys, all of this is available. It's localized to your area. The link in the description, and it's completely free. Check it out, and thank you to them for making that possible for you guys. All right, let's get into this, people. We have got some stuff to talk about. I cannot wait. All right, let's go to the first one. So this one's coming from Silencer Co. Let's effing go. Breaking. The Fifth Circuit has officially withdrawn its panel opinion in USA versus Peterson that wrongfully asserted suppressors weren't protected by the 2A. This is a very big deal. This is an unprecedented step towards acknowledgement that suppressors are protected by the Second Amendment. Now, of course, that is a massive deal. In fact, there was a huge uproar on the internet side, in the gun world side of the internet, about how this would even be allowed to be. Well, the DOJ made a favorable recommendation. They pulled back the poor recommendation, or the poor ruling, and now they're coming out with something else. Guys, we are making moves and actions, and we are literally making our opponents, the gun controllers, go right into this mode. And this was the favor from all you guys today. We made this little gem. Check this out. Mom's Man Action, finding out about the suppressors on the short. Check this out. All right, that was by far y'all's favorite, and it's all available on X at Braden LOA, just for your consumption pleasure. But let's get back to it. That is the one you guys like the most. Now let's jump over to Larry Keene real quick. This is the SVP of NSSF. This is a pretty big player. Very unusual step, indeed. The Fifth Circuit takes the unusual step in the suppressor case. All right, let's go here. Firearms Policy Coalition, FPC. The Fifth Circuit has withdrawn its horrifically flawed decision that said suppressors aren't arms. The court has not yet said what it plans to do regarding our en banc petition. Now, isn't that interesting that all of this is dropping at the exact same time that the suppressors and the NFA and the short are all in conversation in the legislature? The DOJ, this is happening. The judicial system, this is happening. Guys, you're making the difference. This is directly because of you. This is not because someone woke up and decided in the government that it's the right thing to do today. No, it's because you guys are being active and you are directly putting pressure on people. And I'm here for it. Now, this is the United States versus Peterson, the FPC-backed challenge to flawed suppressor decision. As you can see here, the federal crime appeal in case where a 3-judge panel ruled that firearm accessories, such as suppressors, are not protected by the Second Amendment. That's where they were until today, of which they did this part right here, court directive withdrawing opinion. And that I have for you right here. United States Court of Appeals, Fifth Circuit Office of the Clerk, June 17th, 2025. You can see it right there. Pursuant to the court's directive, the opinion in this case has been withdrawn. Guys, this is extremely unorthodox. This does not happen a lot. And double that down again with the fact that it's usually not on the gun rights side either. There's a seismic shift that is happening, that is occurring, that you are a part of. And don't miss it because you're in it. Zoom out and look. You'll see something pretty incredible. But Let's continue on to American Suppressor Association. I already showed you that tweet. They showed that they have the exact same list of appeals. And now this I want to wrap up. This piece by Bearing Arms. This is from Cam Edwards. This is actually a really good piece, and I want to bring y'all's attention to it because I'm going to zoom in a little bit. He brings up some very interesting points. Back in February of this year, the Fifth Circuit Court of Appeals issued their opinion in U.S. v. Peterson, upholding the conviction of a man sentenced for possession of an unregistered suppressor. In their ruling, a three-judge panel held that suppressors do not trigger Second Amendment protection, arguing that a suppressor by itself is not a weapon. In April, the Trump administration asked the Fifth Circuit for a 30-day delay in considering the en banc petition to allow the government an opportunity to further consider its position. The appellate court granted that request, and in May, the DOJ submitted its reply, stating that the government has reevaluated its position in the case. Guys, all of these things are moving in your direction. These are not moving away from you. These are moving directly in your side. You're making moves. The fight is not over. It's never going to be over. But you are dealing so many body blows to the gun controllers that they do not know how to deal. All right, let's keep on going. Because I'm telling you, the more you push on this, the better. Now it appears the Fifth Circuit is doing just that. Today, the appeals court issued a directive to both plaintiffs and defendants, letting them know that the panel's earlier opinion has officially been withdrawn. So is this good news? Second Amendment scholar and attorney Mark W. Smith of Four Boxes Diner seems to think so. In a post on X, Smith opined that the panel 100% messed up its decision, but now it looks like they've intended to fix their error. I certainly hope that's the case, but I'm not as confident as Smith in the panel is going to completely reverse itself. On the surface, anyway, the panel appears to be following the suggestion of the DOJ, which is good, to correct the panel's opinion analysis. But the Trump administration also argued that the panel should still uphold Peterson's conviction and the constitutionality of the National Firearms Act taxation and registration requirements. Now, of course, I'm going to hone in on that because what are we fighting on right now? We are consistently fighting about the NFA being a tax versus being fees and licensure. It's a tax. If you wanted a suppressor and you want a machine gun and you want an SBR, you literally have to have a tax stamp. The original documentation from the NFA witness testimony in Congress in 1934 by the sitting Attorney General was a tax. The power of taxation was the only way they could infringe upon their rights. We've been through this. This is a well-known thing in our circles. We all know this. That's the big thing. National Firearm Act's taxation and registration requirements. Because if you take away the taxation, they have no ability to continue to infringe upon the rights the way that they are. Peterson's attorneys also argued that the DOJ's position opens the door to taxing and registering all firearms in the future, though it noted, and this is important, that, quote, the government apparently recognizes that such a result would be untenable, meaning it's not gonna happen. Anyway, I'm not gonna hit that too hard. Professor Smith says it's almost unheard of for an appellate court to withdraw an opinion once it's been issued. That's very true. And I can't recall this happening in my 20 plus years of covering the Second Amendment in the court, says Cam Edwards. It does appear likely that the panel will conclude that suppressors are protected by the Second Amendment when it issues its new opinion. If it is issued that Second Amendment is protecting of suppressors, guys, you're talking about a outright ban on something that it's very similar to the AWBs and the magazines. It's that same realm. It's that same realm of complete and total control. If you go into this realm of suppressors being firearms, then now they're given protections versus non-firearm items. Does open up the NFA tax conversation, but we're working on that in Congress right now. That's what I've got for you guys. I'll probably have another one for you tonight because so much stuff is going on, but I will see you on the next one, and I cannot wait to hear what you think in the comments below. Follow me on X at BradenLOA, and make sure you hit that subscribe button. See you later.